All rise. The Court of Appeals, Division 1 is now in session.
Please be seated. Good morning. We are here for oral argument in Trade Printers v. PDF Print, CV21 0356. Each side has 20 minutes for argument. You may reserve some. I just ask that you do it yourself. We don't give you that service up here. And there's a clock on the podium. Proceedings are being recorded, audio, video, so if you could introduce yourself at the outset and your client, that would be appreciated. We've read the briefs, discussed the case. Keep that in mind when you're arguing, and with that, counsel, you may proceed.
Good morning, Your Honors. Eric Schiffer on behalf of the appellant PDF Print Communications, Inc. Your Honor, I'm before the court this morning to request that the court reverse the trial court's order granting summary judgment in favor of plaintiff trade printers in this case. Your Honor, the issue in this case involves a dispute over the purchase price of a business, and more specifically, the inventory and how that inventory was allocated in the purchase price. And according to the plaintiff, the inventory was to be paid as some sort of a flat fee regardless of when or how it was used. According to my client, the inventory was to be, the amount paid was to be determined by use of that inventory over a 6-month period post-closing. That dispute led to this lawsuit. The trial court reviewed the contract. There is a final signed contract in this case, found that the contract was unambiguous, and on cross motions for summary judgment, denied PDF's motion for summary judgment and granted trade printers' motion for summary judgment. My position this morning, Your Honor, is that the trial court simply should have denied both of those motions as triable issues exist. And in order to look at that, obviously the place that we start is with the contract itself.
Okay, and so counsel, I'm going to direct you to different parts of the contract, and we'll talk about them.
Sure.
So 3.01, purchase price. After the do you have the contract in front of you?
Let me get it, Your Honor. Yes, Your Honor, I'm with you.
Okay, so after this is explaining that we have two parts to this deal. One, well, at least the purchase price, the $165, and then this inventory. So it reads, plus an amount equal to the value of inventory of goods and supplies owned by seller. Okay, the word owned, how is your argument consistent with that, the plain meaning of the word owned?
Well, Your Honor, the word owned means that the inventory is still owned by the seller. And if my client wants to purchase that inventory, he has to do so as he uses that inventory. And if we look at that same contract at Exhibit 3.02, which is also part of it.
Sure. No, and I'll get to that.
Sure.
But you know what? We'll jump there right now. So you would agree, and I think the trial court got this wrong. They called it a fixed contract. This is plainly a variable price. Okay. We have a sure price and a potentially price, definitionally variable. What is the variable? Well, I'm not great in math, but I figured out it's inventory. Okay, that is what it is to the penny in the schedule. But why is it a variable? Is it a variable because the value might be different of the owned inventory, meaning we have a a universe of inventory, and that's the variable? Or is it variable based upon use? So to me, that's the entire case, is we have a variable price, it is about inventory, and it's either variable because of value or variable because of use.
That's exactly correct, Your Honor, and it's for that very issue that you pointed out that we believe the trial court should have taken the view from Taylor that if there is a reasonably susceptible interpretation of this contract to support my client's position that it's use, that we need to look at that parole evidence, because the evidence to be reviewed in this case, we believe, shows that use was the intention all along here, at least from my client's perspective.
And that's a good point, but let's go back to 3.01. I don't, after plus, that doesn't favor your client. There's no mention of use, and the description is owned.
Well, I would just offer one thing, Your Honor. It's the language in 3.01 says plus an amount equal, not an amount certain, an amount. And those words matter. If we look at the Smith versus Melson case, in that case, the Supreme Court turned the entire decision on the use of the phrase the exchange, exchange in all capitals, versus an exchange. That specificity mattered in Smith versus Nelson, and it said the parties, there is a disagreement as to whether or not any exchange mattered or whether or not the specific land exchange at issue matters. So when we look at this document, and you're absolutely right, an amount equal. So our position would be that's not an amount certain. That's an amount to be determined consistent with Exhibit 3.02, which says potentially up to this amount.
Or not an exhibit, 3.01B. Okay, so now we're going to be looking, we got to know, we have a variable price, not fixed. And what is it? What's the variable? And so here we say, we get to an estimate of the value of inventory on the date of closing. So doesn't that lean in the direction that the variable is value rather than use?
I don't know that it's fair to be able to separate those, because there has to be a value so that there's a structure to the arrangement. We know what we're talking about, but then there has to be use to talk about how that value is ascertained. In other words, if the value is silent, then as we're using it, how do we know what it means? So I think those two have to be read in tandem. I don't think you can eliminate either one, and I don't know that either one carries the day.
Okay, so then we have 302, and we have an exhibit, and so we'll turn to that now. Your point then is the difference between sure and potentially is use, and you look to the parenthetical on the class 4. Is that accurate?
That, in addition to, if you look at the physical assets description, it says 155,000 sure, underlined. That's not in the parentheticals. That much is for sure. And then it says parenthetically, could be up to another could be a total of $370,000.
And we can do the math.
Correct.
155 is 25 plus 130. So not a surprise.
Correct.
That's the very bottom. Okay. I don't see anywhere in the court's opinion the words, the Superior Court, sure or potentially. Was that argued? Why isn't it at least accounted for?
Well, I think, Your Honor, because the Superior Court looked at the language of 4.01, which we haven't gotten to yet, and made the determination that the language was unambiguous. And that, I believe, was error, because in Taylor and its progeny, ambiguity is not the beginning point for an analysis such as this. The court in Taylor specifically said you can't rely on ambiguity. Even in Taylor itself, you had a trial court find that the underlying language was ambiguous, and then you had the Court of Appeal in that very same case find that it was unambiguous. So the court in Taylor required that if there was a reasonably susceptible interpretation, and I think as we're discussing this, Your Honor, it's clear that my client's position is reasonably susceptible. We're not completely out to lunch on this. I think it's reasonable in that instance, under the rule in Taylor, that parole evidence needs to be considered to figure out how was the value measured? What did use mean? And if we look at the language of the agreement, the word as used is highlighted 3 times. If this was simply a flat fee to be paid in full at the end of the term, what does it matter how it's used? Why would that term be so highlighted and so important? And I think if you look at the precursors to this agreement, you'll see why. Because the language in 4.01 has been changed since the beginning of the letter of intent process.
But maybe that's a temporal concept, as used, meaning I'll pay as I go.
Correct, but why is it highlighted 3 times? It's if that's the case, it's no different than any other meaning in that paragraph. Why emphasize that in such a basis?
But counsel, I mean, and this is what the Superior Court said in its ultimate ruling, and you're going to have to confront it here, so I'll just ask. How do you account for the fact that they're talking about a payment by the final payment of any remaining unpaid balance by that point?
That was a term that was introduced about the 3rd or 4th iteration of the back and forth between the parties. And I don't know how we can account for that, why it is included here. And I understand it's certainly not a good fact for my client. But I think when you look at the contract as a whole, when you look at Exhibit 3.02, talking about a potential amount to be paid in inventory, I think you can't ignore the fact that there is some disagreement as to how much of inventory is supposed to be paid. I don't think it's as cut and dry, and I certainly don't think it's unambiguous as the trial court found it, therefore not even looking at the parole evidence. I think it's relevant here, Your Honor.
So what about this interpretation of the remaining unpaid balance? There's money that's still owed, which might be what we used in the last month, and that is the remaining unpaid balance. Did you make that argument?
That's a fair argument, Your Honor, but again, we're here on summary judgment. The issue is triable issues. We're not trying to figure out who's right here. We're trying to figure out whether a trier of fact should get to decide who's right.
Right. We're trying to figure out whether to look at parole evidence. But you just said it's not a good fact for...
Correct.
Okay, so you did or you didn't argue that? I mean, I guess, we would consider it anyways, but
right.
That the remaining unpaid balance untethered to something is meaningless.
I believe that the argument in the lower court did address that. I was not counsel, so I don't know for certain. But I know that the issues that we're discussing were certainly before the trial court. And what the trial court did was simply find this provision, specifically 4.01b, to be unambiguous. And because of that, she did not consider any parole evidence. And we believe under Taylor, that was the wrong analysis. In order to get the interpretation of the contract, the totality of the circumstances have to be considered. And Taylor says we need to look at all of this evidence to see if it varies the terms or if it explains and helps to interpret. And that simply was not done here, Your Honor.
So reasonably susceptible is, well, like many concepts in the common law and even statutes, kind of unhelpful. What does that mean?
I think it means, and there's language in Taylor to suggest that if the language is not, I believe it says, bizarre or unusual, and certainly what my client has proposed is not a bizarre or unusual.
Taylor says that?
It does talk about, it says the more bizarre and unusual an asserted interpretation is, the more. The more. So I think you're right. There's no clear definition of a reasonably susceptible. I don't think it's, but you look at the word reasonable. It's not an unreasonable position looking at Exhibit 3.02, which talks about a range and up to an amount. Looking at as used being highlighted 3 times, it's not unreasonable for our client's position to be, no, our understanding was that the inventory was to be paid as used. And if we look at the parole evidence, if we look at the letter of intent, the language we're arguing about wasn't even there. So that is a piece of evidence to suggest the parties weren't even contemplating that. That language was added later on in the process, and after that language was added, Exhibit 3.02 was added after the fact. So you've now got competing understanding is going back and forth, and our position, and believe Taylor supports this, is that the trial court, to get the totality of the context of what the parties interpreted, because that is the fundamental purpose under Taylor. What did the parties intend here? And it's very clear what PDF intended. The intent was to pay for this inventory as it was used, and it certainly makes no sense for my client to send an email 6 months after the deal, 7 months after the deal closed, saying, just giving you an update on the inventory. If it was all to be paid for anyway, that was a ridiculous thing for my client to have done. So obviously there was not a meeting of the minds on that point.
I think it's an overstatement saying it's very clear. But what is the context of the movement here? So it's a plaintiff moving for summary judgment, which is qualitatively different. How does that impact what happened here?
Well, the issue is triable issues determination. The trial court seemed to have taken the position that I've got to decide who's right on this contract here. And our position is, when we're not appealing the denial of my client's summary judgment motion, let that stand. We believe the better position to be taken here is nobody wins. There are triable issues. A trier of fact must decide whether or not this parole evidence gives context to what these parties interpreted. If that's the fundamental purpose under Taylor, we have to respect that. We have to let the trier of fact decide what was meant by as used, highlighted 3 times. What was meant by the parentheticals.
What's the burden of a plaintiff to get summary judgment? It differs from a defendant.
Right. They have to satisfy the standards by preponderance of the evidence. I don't know that it's that different. They have to show that there's no triable issue of fact and they're entitled to judgment as a matter of law. And I believe there is a triable issue of fact here. And again, I'm not standing here telling you my client should win this case. I'm telling you that there's an issue that we believe a trier of fact should be allowed to determine. And it's supported by a letter of intent. It's supported by emails between the representatives. It's supported by the varying language that was included in a process of finalizing this documentation. It's supported by the declaration of Julie Merman. The trial court never even looked at that declaration. This was an employee of the seller for almost 30 years who said, yeah, there's an admission. The owner told me he was only going to get paid for 6 months as the inventory was used. That wasn't even considered by the trial court. We believe all of that should have factored in, and you don't stop at the language, find it unambiguous, and refuse to look at anything else. That's not supporting the teaching of Taylor. That doesn't give credence to any of the proffered parole evidence, and it doesn't properly get into the context of the situation, the totality of the circumstances as to what was intended. That's what the judge's role should be. What did the parties mean when they did this? Clearly there was not a meeting of the minds here, and it should be for a trier of fact to decide that, Your Honor. I see I have a little bit of time left. If I could reserve that for rebuttal.
Sure.
Thank you very much, Your Honors.
Good morning, Your Honors. Claudio Iannatelli on behalf of Trade Printers, the appellee. Your Honor, the standard for summary judgment on a moving plaintiff is to prove that no reasonable juror could find in favor of the defendant. No reasonable juror could have found in favor of the defendant here because the defendant remained silent, completely silent. It offered no testimony. Counsel may make arguments, but the defendant here did not. The testimony, this was at summary judgment, so what are we talking, affidavits. Or depositions, or interrogatories? All of it, none of which was submitted. The signer to the contract here was Kevin Mullaney on behalf of PDF. He submitted no declaration as to what his interpretation of the contract is. We can sit here and talk and debate over whether the contract is acceptable, different interpretations, but what we're missing is an interpretation by the contracting party. You do not have anywhere in the record any testimony by Mr. Mullaney in which he states, I enter into this contract and sign the contract based on this interpretation. They strategically did not have him perjure himself, as he had already perjured himself through pleadings. Okay, we have a case from a party who alleged that the trade printers had engaged in fraud in shifting documents, allegations that were meticulously proven as false by the own records of Mr. Mulaney's own emails, which he had all along.
So let's move back to the plaintiff's summary judgment motion, which we've characterized and I've characterized as a heavy burden, okay? Qualitatively different than the other kind of summary judgment motion. And what, like you said, the question is whether a reasonable juror could find, and usually that has to do with the record evidence. It's summary judgment. Discovery closes, we have all of this. Here, isn't that, like, we don't even get there because the question, as decided, was the face of this contract is clear, so clear that we don't need to go outside the four corners, such that these affidavits you're talking about wouldn't have even come into play.
Your Honor, as even Taylor points out, the parole evidence has to be considered in the light of the testimony and the position of the parties. You don't put it without a basis to whether or not, it's not what counsel might wish to argue now on appeal or even before a superior court. It's not, if we leave it to lawyers to argue with a contract.
I think what, and he'll correct me if I'm wrong, I think what Judge Weinswag is getting at is if up front the determination is that the contract is unambiguous, why would the court have looked at parole evidence? In which case, why would the affidavits have mattered?
Well, because their position is, first of all, the position they took was that the court was to look at the contract on its own without consideration of any parole evidence. That was a position that the defendant took. And then that the contract was unambiguous. Okay? The answer to the issue is, or the question is, whether or not in evaluating whether or not there is an ambiguity, you should look at the prior communications of the parties.
And so your position is legally the court must look outside the contract in order to determine if the text of the contract is
my position is that the court starts with having competing interpretations by the contracting parties, and because we're at summary judgment, the only way that could have been done was through sworn testimony, be it deposition or be it by affidavit. I don't care what somebody who was not part of the contracting process thinks she heard at some point prior to the signing of the contract. She doesn't know when she heard what she thinks she heard. Furthermore, counsel made various references to the letter of intent.
Well, no, before we go there, okay, we've got a decision here from the Superior Court. We don't have to sort of speculate as to what was considered and what wasn't considered. And we both know you can file a motion for summary judgment before any discovery is taken, and the other side will have to move under what used to be, well, they changed the subsection, for more time, okay? Where in this decision by the trial court is there any indication that the court was looking anywhere other than the ink on the contract?
Because she mentioned 2 or 3 times that the defendant's position and the parole would have the court ignore the provisions of the contract. And in fact, it contradicts the
position is different than, I mean, you were just talking about affidavits of negotiating parties. Of course, it's an adversarial system. We have issue clash. We have different positions. And the court has to account for that. Where does the court say an affidavit or at any point look outside? I mean, I would think you'd say the contract is ambiguous because that's what this judge said, and we don't need to look any further on the face of the contract.
That was the position we took. We said the contract is unambiguous. The contract was modified. Okay, the contract. Let's not overlook. And I think I was perhaps in a different way getting to the same issue. The letter of intent had the parties paying on a period not to exceed 7 months. Okay, the contract then gets changed on a period not to exceed 6 months. So that very provision that we're speaking of was already changed. We then get further clarified by adding the language of the remaining unpaid balance. So the letter of intent states the terms are not binding on the letter of intent. There is no agreement between the parties. So our position was, in this case in particular, that the preliminary discussions are excluded by the letter of intent itself. The terms of the letter of intent is that is not to become the terms of the agreement. You have
That's not before us. I mean, before us, we have a summary judgment motion that interpreted a contract as unambiguous.
Yes.
And goes through the provisions and explains why it's unambiguous.
Yes.
And that's what's on summary judgment. Whether or not it might have some trace of ambiguity such that we go to parole evidence. That's the only thing before us. And I guess I gave you a preview of what it might mean, but what do the words potentially and sure mean in Exhibit 3.02?
So as the contract recognizes, the ultimate inventory value that was to be paid was going to be determined at a future date by a process that the parties described in Article 3. And so at the time that Exhibit 3.02 is inserted in the contract, the inventory value does not exist yet. And inventory is going to change.
Well, it exists. I mean, for reference, as quote, for reference, the value of the inventory on the date of on May 31st, 2018, was $240, a little bit more. So it existed, but your point is that it wasn't certain, it wasn't definite, it wasn't fixed.
That was the variable, that the inventory was going to change. And hence, it recognized that, and it described the process by which the parties would arrive at the inventory count. That evidence was submitted. It's not in dispute. So we arrive at a final inventory amount, and there is the variable. When we get into the as used, that is only as to the timing of the payments, not as to what amount is going to be paid. Further, the fact that it states a period not to exceed 6 months, it's also inconsistent with the notion that it's only going to be paid if used. A period not to exceed means that the payor has the ability to take more or less time. They can't take less time if it's only going to be as used. It's also inconsistent to say that it's only to be paid as used when you're paying $25,000 up front. Okay, so again, that's inconsistent. The contract is broken out into two sections, one that defines the purchase price to be paid, the other that defines the timing of payment.
So the stressing of as used is almost like a customer going to Walmart. They need installment payments because they don't have the cash up front, and so that's emphasized here, I guess, is what you would argue. It was negotiated because that was important, that we didn't want to pay for it all up front. We wanted to pay for it as used. I mean, right, because it's underlined and italicized 3 times. So why is that? I guess that's a better question. Why is it bolded and italicized?
There's no where do we have any testimony that says that bolded and italicized means anything other than the words? I mean,
I don't know about that.
Well, titles are bolded.
I don't know if I need testimony. If I'm looking at the face of a contract, I mean, this is summary judgment from a judge, not going to the trier. Okay, so I think colors, everything's.
Well, then as used is because this party wanted to make sure that they didn't have to pay up front. They wanted to stretch their dollar. As they sold inventory, they made money. They made income. That's rather obvious. As you use inventory, you obviously generated more money than the inventory, which here was priced at cost. No more than that. And so now they built a way by which to pay and not have to upfront the money. But it says not to exceed, not only as used. And let's not forget, what they seek to accomplish here is a forfeiture, of which there is no provision in the contract, and we also have the provision of the contract that allows for adjustments to the purchase price, none of which includes the inventory. And again, we're only dealing, as we're looking at the contract, and as we argue is crystal clear, Article 4, where as use is, if underlining and bold matters, then all caps, bold also matters, and it says payment of purchase price. Okay? The part that as used is you don't get there unless you first have to go to Article 4, which is different than Article 3, which is the purchase price, and Article 4 is the payment of purchase price. So you don't get there until you get to that all caps bold, and then it says payment of purchase price again, and then it says payment at the closing of an amount equal to 165 in cash, certified, blah, 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 and then it goes inventory, a defined term, shall be paid as follows. So first you go back up and you define inventory. What is that amount? Well, we now know $245,000.
So let's go to that. The word owned that is preceding inventory. I asked your colleague, that seems significant. It's not some pro rata. I think that's what is owned or what is not owned. Did you argue that that's sort of the seminal word? I mean, again, it doesn't really matter because we're looking at this contract.
So we did not as much focus on owned. It was part of everything we relied on. But then what we did was also pointed out that not only was it owned, but then the process that the parties were to get together and only count the inventory that was in sellable, that they owned and was in sellable condition, which is against contrary to their interpretation, because if you're only counting the inventory that both parties agree, representatives of both parties must agree, and only in sellable condition, what difference does it matter if the issue is whether it's going to be sold or not, whether it's going to be used or not? Why do we put down the component of sellable? That's because that's what was to be paid, what they agreed upon.
Let me steer you to another issue before your time runs out, and that is the lease payments.
Sure.
Isn't a court supposed to consider mitigation before granting some certain on summary judgment?
A court cannot impose mitigation on a commercial landlord where the tenant continues to use the premises for the intended purpose. Here, the purpose of having a 6-month lease was to, A, to finish production, and B, store their equipment until they could relocate it to a new location. Again, you have no testimony from the defendant.
Well, you're saying there's no mitigation because there's no breach. They had to stay there the 6 months.
They didn't have to stay 6 months, but they did. They kept. It wasn't for them to occupy to have a storefront. It was there to keep equipment as well as to move the operations. They admit they kept their equipment for the period of time for which we seek rent.
But they were already in holdover at that point, weren't they?
No. It's a very short holdover period that we didn't.
But that wasn't my question. My question was they were already in holdover by the end, weren't they?
Your Honor, at this moment, they paid for 4 months.
Right.
And we sought 2 months. My specific recollection is that, or 3 months. I'm sorry. So I think that there was an extra month. Yes, but they continue to occupy. Okay? And so how do we mitigate when they haven't vacated? Is there a letter saying we moved out? No. They kept their equipment on site. And so are we saying that every time a tenant breaches that we now have to go put the premises out for lease to someone else? Because that's effectively what they're saying. The minute that a payment doesn't come in, I have to go and try to relet. That's not what mitigation is. Mitigation deals with the period of time left on a lease when the tenant did not use the space. What a mitigation, the duty to mitigate arises when the tenant no longer has control of the premises, and the landlord just wishes to just kick back and collect rent.
Actually, I think mitigation is when someone with a claim chooses not to avail themselves of their claim and incurs purposefully damage. That's failure to mitigate.
Your Honor, I've done a lot of landlord litigation, and I'm not aware of a single case that says, landlord, you failed to mitigate because you didn't throw your tenant out soon enough. We have commercial cases with a year's worth of unpaid rental amounts for the period of occupancy. Okay, so that...
I don't know, your personal experience, we're focused on the law here. You're saying it was a 6-month lease agreement, they left their equipment there, so there was no duty to mitigate. That's your argument.
That's it, they continued occupied, okay? And again, there's no evidence from them on any of those issues. And again, I appreciate the summary judgment might be a high burden at times, but we also can use summary judgment to avoid trials. That is a purpose of summary judgment. If there are no tribal issues, why does my client have to go to trial? We submitted a declaration that detailed the contracting parties' steps, it detailed how the contract was arrived at.
And you're saying the court considered that?
Of course.
So why hadn't the court considered other parole evidence?
Well,
I mean, that really throws this whole thing into... So you're saying that the court, in reaching this summary judgment, did go out, but only looked at part of the evidence.
No, wait a minute. Parole evidence, my client testified as to the signing of the contract, okay, and what the contract meant, okay?
The face of this contract is what this court goes through paragraph by paragraph. There's no reference to testimony, and that's the very point of, a contract is a contract, and we don't want to disturb that absent a real ambiguity. But you're telling me that the court basically chose what evidence outside the contract to consider, like an affidavit. You're saying it considered an affidavit of your client?
Well, I guess she doesn't reference the affidavit of her client. I'm saying our motion was supported. Our motion was supported. Our motion introduced evidence. Their motion or their response, they had two opportunities. They did not submit any evidence. They had no admissible evidence.
What about these emails? I mean, what are we here then? The parole evidence. What's the parole evidence?
But don't we do it based on, don't you still have to have admissible evidence in summary judgment? We objected to what they submitted on various bases. We properly follow the summary judgment rule. Your Honor, I like to know when, as a lawyer, I no longer need to bother seeing whether my client will agree with a declaration that I need to be signed.
Right.
Shouldn't client sign declaration?
Here's the difference, counsel. If it's going to the trier, or if a judge is going to look at the four corners of the document and say it is so plain and apparent that I am going to grant judgment as a matter of law, that is the difference. So, yes, of course you need evidence, and if you didn't, that's malpractice. I mean, it's going to be tried possibly. But the decision of a court interpreting a contract, no, you don't reach out and consider some evidence, but not other because it's parole evidence.
But that evidence presented has to come in an admissible way. They had no testimony from a contracting party. It is the intent of the parties that governs the rule, not the intent of the lawyers. You don't have a party speaking.
Certainly. The absolute guiding point always is intent, and that's why a judge, when they're going to call it on summary judgment, has to find that it's unambiguous. But okay, thank you.
Thank you, Your Honor. A couple of points. I'll start with what I hope is the quicker of the points. On the lease issue, the declaration submitted by Mr. Stewart said he didn't even enter the property for 3 months.
Tell me, what was the parole evidence here?
That
you want to get in, that you want the court to at least consider.
Well, the main one is the letter of intent, which was submitted by the moving party. So the evidence was before the court. The letter of intent specifically says It offers a glimpse as to what the parties intended. It does not include the very language of 4.01 that ended up in the final contract.
Did this Superior Court consider evidence outside the contract?
Her decision was that the language is unambiguous.
Well, right, and that's the standard.
Right.
But did she, I think that's, we'll go back.
If she got there, I don't know that it's articulated in the decision, but if she got there, it was based upon what the moving party said in their declaration. But I would say this: number one, on appeal, this is a de novo review, so certainly you can give some deference to the trial court, but this is de novo review, and you have the right to review this anew. But number two, I think it's evident that the trial court only looked at the contract. I think she only found the language of the four corners says X. It's unambiguous. Maybe just like, Mr. Stewart says, I'm finding it unambiguous. End of story. You win the case. And they keep harping on, well, our client didn't submit a declaration. The evidence was submitted. They submitted the letter of intent. What we argued in our papers was before the court. The letter of intent was there. It could have been looked at. Under Taylor, it should have been looked at, because if you looked at it, the very language we're talking about didn't exist in the letter of intent. What did exist was a chart on page 6 of the letter of intent that says, as Your Honor pointed out, all of the inventory is owned by trade partners or trade printers, and 0 of the inventory is owned by PDF.
But Counsel, doesn't the incorporation clause have some sort of effect on that, on the value of that evidence? Doesn't that become an exercise in futility, because now the four corners of the signed document have superseded everything else, which now are just negotiation?
Well, Your Honor, that's the premise of parole evidence. If we can't ascertain the intent of the parties, you have to look at the situation. You have to look at the circumstances. That's what Taylor says. The circumstances were, the parties said, here's a letter of intent, and in this letter of intent, here's what we're willing to pay you. Here's the inventory that you trade printers own, and we, PDF, own 0 of it. And what we're going to do is we're going to pay you as we use it. That was what the letter of intent showed. That was never considered by the trial court. Our client's position was reasonably susceptible to that interpretation. The trial court just never got there. Determining the contract to be unambiguous on its face is specifically prohibited by Taylor. They said, don't do that, court. Try to ascertain the underlying intent of the parties. And briefly on the lease, if I could just revisit that, there was never a lease agreement. There was up to 6 months of a monthly agreement. It's undisputed that my client left in October, and it's undisputed that the owner of the premises didn't even come back until January and determined that there was a breach. There was absolutely, not only was there no effort to mitigate, there was no effort to even come in and get the property when he was told that it was gone. I see my time is up, Your Honor. If there's no other questions, we will submit the matter, and thank you very much for your time today.
All right, well, thank you both for your argument. It was very helpful, and we will take it under advisement, have a decision in due course, and we'll stand in recess to get ready for the next argument.